Head Department of Law and Human Rights, Refaat, my colleagues from University of Asia Pacific, and my dear students. Very good afternoon to all of you. Assalamu alaikum. We have been arranging this series of lectures over the last almost 2 years. This first lecture was delivered by Dr. Kamal Hussain, and then we had quite a few of the most eminent lawyers, judges who have come here, delivered the lecture. And but about today's speaker, you have heard briefly from Dr. Ishaq Siddiqui about his background. I think he is an exception in the context of our country. I had the privilege of working with his father. Many of you may be knowing that he was one of the most eminent lawyers in the country, Barrister Syed Ahmed, who became a legend in his lifetime. So in 1996, when I was invited to join the caretaker government by the Chief Advisor, Justice Habibur Rahman, I had the privilege of working with him in the Council of Advisors, and I learned a lot from him. The sort of in-depth knowledge, not only about legal matters, but the maturity, because at that time I was relatively young, and so he would maybe suggest some action immediate, but with his decades of experience, he gave his opinion, which was much more mature. So I remember many incidents, but after that, he used to depend a lot on me on technical advice, engineering, starting from problems with buildings which were under construction in Dhanmondi, and also some legal matters. For example, I remember that there was a suit between two, the oil company and I think our national Petrobangla, about the volume of oil. And the volume of oil is very sensitive to temperature. So at temperature at which the measurement is carried out, that's very important in determining how much you have to pay to the supplier. And there's always an attempt to manipulate. So he got in touch with me and then asked for my opinion. Anyway, but Dr. Justice Syed Refaat Ahmed, I always confused about which one comes first. Is it Justice Dr. Syed Refaat Ahmed? The hierarchy is difficult to establish, but it's a pleasure to welcome you to our campus. Although this is a rented premises, but our own building is next door, and we are going to connect maybe within the next few weeks. The design is ready by a bridge. The gap is only about 15 feet. So this is almost an extension of our campus. I know there are many students and faculty members of law and human rights who are not very happy that they are continuing to stay in the rented premises, but we are also moving the department to the new building. Some of the classes will still continue to be held here, and others will be held in the new building. So I always tell people that you don't feel the difference. You entered our main building, then you don't know when you are moving to this building or you are continuing our own building. So again, it's a pleasure to have you here. We look forward to listening to your presentation. I'm sure the faculty members and students are going to benefit from your experience, from your knowledge about law, how it has been practiced in Bangladesh. So with these few words, I would like to welcome and request Dr. Justice Syed Refaat Ahmed to come and make his presentation.
Vice Chancellor, Professor Dr. Jamil Reza Chaudhry, Head of the Law Rally, someone I've known for, well, my family's known for generations, Mr. Karim Reza Chaudhry, my tutor from Dhaka University, Dr. Shadin Malik, members, faculty, students, in that I almost feel that I come back to the folds of my own family, because many faces here have been known to me and my family, as I said, for generations or less. I will be taking about 40 minutes or so to speak, speaking with Mr. Saqib Rahman here. And I think you've taken up teaching administrative law here, right? Okay, so it's right up your alley at least. Students of administrative law can be familiar with the constantly shifting certiorari has in particular been the subject of the last 3 centuries. Appreciate the fact that over the centuries, the courts in England in particular have laid down landmark findings and judgments touching on certiorari and judicial review on subject matters like finding of facts, the no evidence rule, unfettered discretion, as indeed considered in the landmark cases of Padfield and Tameside, natural justice and the need for a fair hearing decided in Ridge versus Baldwin, legitimate expectation, Wednesbury reasonableness, etc. But the 2 cases that have gone down in the annals of administrative law history as being, as really landmark decisions are the 2 decisions of the House of Lords in Anisminic Limited versus Foreign Compensation Commission and R versus Hull University Visitors ex parte page. Now, these 2 decisions were important because they widened as never before the authority of the courts to interfere with judgments or decisions of quasi-judicial bodies, administrative tribunals, or lower courts. If it was seen that any error of law was made by any such body, then it would right away, outright, stand to be quashed by the courts in judicial review, sitting in judicial review, without regard to the obstruction that had sort of been adopted by the courts earlier on. But the courts would not interfere earlier on if there was found to be an error made, but by a tribunal that was acting within jurisdiction. That was struck out, and that regardless of the fact whether a tribunal is acting within or outside of jurisdiction, any error of law would justify an intervention in judicial review. But that was in the past. What's happening today? And happily, again, judicial innovation has not stopped. Not in England, not in Bangladesh. And that is what I shall be placing before you today. The courts are constantly, in either jurisdiction, striking a balance between changing modes of making administrative decisions and trying to gauge the extent to which these affect the rights of individuals. Under our Constitution, an aggrieved person, in order to agitate his claim, one comes into play in relation to the infringement of any fundamental right guaranteed under Part 3 of the Constitution. Article 102.2 presupposes the availability of the various writs and may be appealed to for reviewing actions and operations in the public domain, such actions being otherwise the preserve of the executive organ of the state. Article 102.1 sets itself apart from Article 102.2 by bringing within its purview a wider group of individuals, an authority on whom the court may, on judicial review, hold sway. To government functionaries must accordingly be seen as an appendage made to the broader category of any person or any authority by way of abundant caution. That appendage in Article 102, Clause 1 appears in a similar form, however, taking center stage in a writ of certiorari under Article 102A2. When fundamental rights aside, the focus is on the legality or not, per se, of an action or decision emanating from any person performing functions in connection with the affairs of the Republic or of a local authority. The emerging judicial consensus in this jurisdiction is that Article 102A2 allows for identifying amenability to judicial review not exclusively by reference to an obvious derivative public status of a person, but increasingly by the public domain within which it operates and prevails, irrespective of its derivative status. The ever-increasing reality of public-private partnership of providing services to the public at large and in regulating public activity has blurred the traditionally held view that a written certiorari can only validly be addressed to public functionaries. That traditional view indeed risks being exposed as a fallacy, because it belies the fact that public functionaries, in the strictest sense, have in reality long forsaken their perceived monopoly over public affairs, and that private and public enterprise and endeavor are intertwined in the conduct of business of the Republic or of a local authority. Create opportunities for private bodies to strike a partnership with the public sector, to keep the wheels of commerce and service delivery well-oiled and operating, to assume a hybrid character in discharging responsibilities in the public interest. A restrictive approach in the application of the writ of certiorari. A more pragmatic view is instead to analyze the type of function performed by any decision-making body. The landmark case of R versus Panels on Takeovers and Mergers, the Court of Appeal was concerned with the actions on the Panel on Takeovers and Mergers, which it termed to be a truly remarkable body, in that it is an unincorporated association. The issue of judicial reviewability of the panel's actions wielding considerable collective power, compelling compliance by others, loomed large in the Datafin case, given the very real potential of exercise of such powers arbitrarily and manifestly unfairly. Sir John Donaldson, the Master of the Rolls, in finding that the court in these circumstances has jurisdiction to entertain applications for the judicial review of the panel's decisions, considered two opposing views forwarded by counsel for either side in that case. Counsel for the panel understandably submitted that the Queen's Court's historic supervisory jurisdiction does not extend to a body as the panel, given that the panel's power is not derived from legislation or the exercise of the prerogative. On the other hand, and understandably so, counsel for Datafin submitted this to be a narrow view, arguing that regard has to be had not only to the source of the body's power, but also to whether it operates as an integral part of a system which has a public law character. So John Donaldson, in these circumstances, revisited at length the judgment in R versus Criminal Injuries Compensation Board, ex parte Lane, where Lord Chief Justice Parker said that the exact limits of the ancient remedy of certiorari had never been and ought not to be specifically defined. The true inspiration for the intervention in certiorari for Sir John Donaldson, however, is derived from Lord Justice Diplock's observations in laying thus, and I'm quoting Lord Diplock here. Tribunal's authority to decide issues submitted at its determination. The earlier history of the writ of certiorari shows that it was issued to courts whose authority was derived from the prerogative, from royal charter, from franchise or custom, as well as from Act of Parliament. Its recent history shows that as new kinds of tribunals have been created, orders of certiorari have been extended to them too, and to all persons who under authority of government have exercised quasi-judicial functions. And Diplock continues to say, if new tribunals are established by acts of government, the supervisory jurisdiction of the High Court extends to them too. It is plain on the authorities that the tribunal need not be one whose determinations give rise directly to any legally enforceable right or liability. Its determination may be the subject to certiorari, notwithstanding that it is merely one step in a process which may have the result of altering the legal rights or liabilities of a person to whom it relates. It is not even essential that the determination must have the result, for there may be some subsequent condition that is yet to be satisfied before the determination can have any legal effect on such rights or liabilities. Imagine a chain with numerous links. Each link has a decision-making role, but each of those decision-making bodies are not uniformly public in nature. Some may be private in nature, some may be public in nature, but because they are interlinked in a decision-making process, and their collective decision at the end of the road affects someone like you and me in the public realm, then if it is the private authority's decision that you are actually aggrieved by, the courts will intervene. Writ of certiorari 200 years ago did not start off like that. 2016, writ of certiorari allows you to go and call that private body's decision into question, and we are doing that in Bangladesh even as we speak, thankfully. Abusing, this is the panel on takeovers and mergers, of the panel abusing its great powers, then it would be wrong for the courts to abdicate responsibility. This led him to conclusively find against the supposition that the source of power is the sole test whether a body is subject to judicial review or not. I will skip over this part of the lecture and take you to the notion of what I was saying, that when you think of a link and that the actions of the private and the public authorities are woven together, it's a mesh. And the courts will not bother to sort of, bifurcate, as it were. You're a part of the decision-making body, regardless of what the source of your power is, you're responsible if you've acted arbitrarily. And that we are trying to bring under Article 102A2. All right? Good. Murray Hunt's book on the province of administrative law, I do not know whether you're familiar with it, but Murray Hunt, in a chapter in that book, in elaborating on the legal, philosophical premises for court's jurisdiction over the exercise of non-statutory powers, spoke of the redundancy of identification of the source of a body's power in determining its public status thus. And this is what Murray Hunt says. The test for whether a body is public, and therefore whether administrative law principles presumptively apply to its decision-making, should not depend on the fictional attribution of derivative status to the body's powers. He says, the relative factors which include the nature of the interest affected by the body's decisions, the seriousness of the impact of those decisions on those interests, whether the affected interests have any real choice but to submit to the body's jurisdictions, and the nature of the context in which the body operates, all come into play. And this is what Murray Hunt, this book, The Province of Administrative Law, it's a compilation of essays on administrative law, dwelling on the, if you will, the best judicial and the legal practices in various jurisdictions, including the United Kingdom, the United States, Canada, Australia, and New Zealand. And not mentioning Data Finn in particular, but in this court, Murray Hunt draws a conclusion that mirrors, it's a spitting image of what the ratio decidendi in Data Finn was. And Hunt says that during the past decade, this book was published in 1987, so it's a bit dated, but during the past decade, administrative law has experienced remarkable development. It has consistently been one of the most dynamic and potent areas of legal innovation and of judicial activism. It has expanded its reach into an ever-broadening sphere of public and private activities, largely through the mechanism of judicial review. The judges in several jurisdictions, and happily in a new edition he can add Bangladesh, have extended the ambit of the traditional remedies partly in response to a perceived need to fill an accountability vacuum created by the privatization of public enterprises, the contracting out of public services, and the deregulation of industry and commerce. Therefore, in dealing with the term public authority as arising within Section 6 of the Human Rights Act 1998, the Court of Appeal in Donahue significantly elaborated on the test of the extent of control over the function exercised by another body, which is a public authority, as an important determinant of the act of an ostensible private body assuming public dimensions. In elaborating on that test and carrying the argument in that regard a notch further than was done again in another landmark case, which I did not go into, which is ex parte Aga Khan, Lord Chief Justice Wolf observed, and he says, what can make an act which would otherwise be private-public is a feature or a combination of features which impose a public character or stamp on the act. Statutory authority for what is done can at least help to mark the act as being public. So can the extent of control over the function exercised by another body, which is a public authority. The more closely the acts that could be of a private nature are enmeshed in the activities of a public body, the more likely they are to be public in nature. In another case, Lord Justice Dyson in Hampshire County Council versus Beer, this was decided in 2003. He says that it is clear from the authorities that there is no simple litmus test of amenability to judicial review. There was a time when courts placed much emphasis on the source rather than the nature of the power being exercised by the body making the impugned decision. If the power derived from statute or the prerogative, then it was a public body, and the decision was amenable to public law challenges. If the source was contractual, then public law had no part to play in it. And he notes that the importance of the seminal decision in the Data Finn case was its recognition of the fact that the issue of amenability to judicial review often requires an examination of the nature of the power as well as its source. So the derivative test and the functional test, both are important in certain cases. But the court, being put on notice of these developments in English law, delved into the issue of maintainability by exploring the various aspects of reviewability of decisions made by a body of a hybrid character. It was accepted by the court. The court decided to invite, happily, and for us, they took opposing views on this issue, on the maintainability of this rate. Mr. Mahmudul Islam took a more conservative view and said the chairman, respondent number 10, had taken the right stand in law. And there was no chance under Article 102 for a written certiorari to challenge his decision dismissing the petitioner. Mr. Rukunuddin Mahmud, however, enlightened us on this whole body of judicial precedents that have been stacking up in the English jurisdiction of the past 2 decades, and it was an eye-opener for us. And we understandably veered towards Mr. Mahmud's submissions. Resultantly, it was accepted that public function need not be the exclusive preserve of the state. Article 102 of the Constitution was found as accommodating the idea of non-state actors operating in the commercial and professional arena that far exceed the nominally private terms of reference and take them into the larger realm of functioning in the public domain. Article 102, Clause 2, therefore, permits of any function that is undertaken in connection with the affairs of the Republic, which the state itself may not perform, but necessarily other bodies, even private, non-statutory bodies, may in substitution of the state or government perform, thereby significantly complementing and supplementing the otherwise essential responsibilities of the Republic due to its citizenry. And we see that normally happening in the areas of provision of education, health, and then you can tie that up with the fundamental principles of state policy in Articles 15 and 17 dealing with these areas, provision of basic necessities including health and of course education. Who in turn teachers serve a public purpose and they have a constitutional rule if you take into consideration Article 17 of the Constitution. By doing so, the chairman is seen to wield considerable authority in the education sector. In that regard, the chairman remains a repository of power that otherwise is the preserve of the state under Articles 15A and 17 of the Constitution to ensure and provide education. The respondent number 10, chairman, resultantly finds himself as part of statutory regulatory regime evidenced in there were some laws that we looked into, primarily the Besharkari Madrasa Shikhok Chakuri Obustan Chakuri Shortabari Bidhi, and various sets of rules and regulations that allowed the committee's chairman to make a decision, but then to be reviewed by the managing committee itself, and then to be finally be overseen by the board. The board was definitely a public body, it's a statutory body. So the decision of the committee chairman was linked to the final decision, the vetting authority of a statutory body. That put into place the data fin and Donahue test, and we sort of we could visualize that link, that chain, where public and private bodies come together and arrive at a decision that ultimately affects a person in the public realm. And so we found jurisdiction, and we held the impugned order to be arbitrary, to be without lawful authority. Happily, that ratio in the Maulana Muhammad Abdul Hakim case has been relied on recently in a 2015 judgment. It possibly has not been reported, but it ought to be reported. In UTI Pership Private Limited, versus Bangladesh and others, in which the High Court Division presided over, in judicial review, the decision of an ostensible private body discharging public body function, that is, the Bangladesh Freight Forwarders Association, which is otherwise a trade organization and an entity incorporated under the Companies Act 1994. The ratio in the Maulana Abdul Hakim case was considered to be overwhelmingly persuasive, and happily the High Court Division, which was another bench, decided to intervene. So that is the present health of, in a nutshell, the present health of judicial activism in Bangladesh as far as judicial review is concerned. And I think we have not seen the last of the applicability of the Datafin and Donahue cases in our jurisdiction. Just a caveat, however, those of you who are sort of itching to ask me, thank you, Lordship, but these are all decisions of the High Court Division. Where is the Appellate Division sit on this? The Appellate Division is yet to iron out its views on this, the spate of innovation by the High Court Division. It's watching by the sidelines and waiting for an opportune moment when it will enlighten us and define the law once and for all as to the extent to which we can go in this direction. But before the Appellate Division does so intervene, the body of decisions is sort of stacking up in the High Court Division. That itself can be again a factor to convince the Appellate Division to decide one way or the other. And it also depends on which bench is deciding which case. But before I end, I'm almost tempted, and I'm happily and coincidentally, we complete a full circle. I am finishing almost on the lines on which the Honorable Vice Chancellor, Professor Dr. Jamil Reza Chaudhry, started, and almost a tribute to another legal luminary, Syed Ahmed. One of his posthumous works, one of his works published posthumously was a brief treatise on certiorari. He had written it ages ago. He passed away in 2003. But under the tutelage and mentoring and immense goodwill of a very close associate of his, Mr. Mahmoud al-Islam.
Thank you all. I thank Dr. Ahmed on behalf of the Reservation Department of Human Rights by presenting the request. On that note, I would like to conclude our session, and an order will ask Professor Reza to conclude the session as a...
No question.
No question. No, we don't have for this session. We don't.
A person with his background, Dr. Justice Refaat Ahmed, his deliberations would be really with the best quality, and he has really lived up to the reputation. This is the first time I've heard him speaking, but I'm sure you have seen the reflection of his experience over the last few years. Whatever you said, although I'm not a lawyer, but even I could at least get some ideas about this judicial review starting our constitution. And he mentioned about his late father, and also the person who worked very closely with Barrister Ahmed late Muhammad Islam, whom I had the privilege of knowing quite closely since 1974. I knew him. So both these legal luminaries have passed away, but we have heard about the contribution which Mr. Muhammad Islam made in this particular case. I'm not sure whether when Appellate Division is going to review. Is there any time frame or?
There is a time frame when about 3 years from the date that the certified copy is collected. The certified copy is being collected. The time is running. The clock's ticking.
Okay. So because I know about some of these cases, particularly this the Parliament building, the Speaker's residence, Deputy Speaker's residence, the High Court Division said this is illegal. But then there was a stay order from Appellate Division many years back, but it hasn't been hard with the Appellate Division yet. So I'm not sure, how, what order the queue is maintained in the Appellate Division. So let's hope that we get the views of the Appellate Division and hope whatever has been given by the learned judges of the High Court Division are upheld by the Appellate Division, so that members of the public have a mechanism to get redressal under this Article 102. Yes. So thank you. I think it has been a memorable occasion, and in the future we hope we have opportunities of listening to your deliberations. And my colleagues, I'm sure some of you already know, and they would also follow very closely judgments you will be giving in different cases. So we wish you success, and thank you again for coming to our university. Thank you.
Our Vice Chancellor to take our guests upstairs for refreshment. Thank you. Thank you.